Welcome everyone back to our lessons on contract law. We've been talking about the creation of contracts in these lessons so far, delineating between the first of these major elements, which is of course the concept of agreement. And we've noted that agreement is comprised of two components, these being the offer and the acceptance of the offer. We've so far spent a lot of our time looking at the offer itself, the one side of the equation for establishing an agreement. We talked about the distinction, for example, between an offer and an invitation to treat, and the various pieces of case law that have tried to establish these principles. In this lesson, what we're going to do is talk about the other side of that equation. We're going to talk about the acceptance of an offer. So, ultimately, the other side of this transaction, being the acceptance, is one that probably merits a little bit more time than we did, or at least than we gave to the previous side of the equation. So we're going to spend quite a few lessons looking at the acceptance in this series before we start to move on to other considerations which form the creation of contracts. So, as a recap, just a quick recap, so far we've been looking at the nature of the offer as forming part of the first step for establishing whether or not a contract exists. The first step is the agreement, and then you also have to have consideration, and you also have to have an intention to create legal relations, and in some circumstances there has to be certain formalities. So it has to be, for example, in writing, although that is not a sufficient or at least a necessary requirement for every single type of contract that may exist. We've looked at the concept of contractual intent, as well as the distinction between an offer and an invitation to treat, and in addition to this, we've also looked at the types of offers which may exist as well. This represents the first half of the agreement equation. We know already that an agreement is an offer plus an acceptance. So we've been looking so far at the first side, when an offerer makes an offer to contract to another party. So this is now going to start talking about the next of these components, which is the acceptance of said offer, the point in which we see the other side of the equation make an acceptance of the terms and of the offer to contract by the offerer. So generally speaking, when we talk about the flip side of the equation, when we start to talk about the other side of the process, we're talking about the acceptance of an offer, we tend to follow something known as the mirror rule. Now, the general rule, which is the mirror rule, is that the acceptance of an offer is something that which ought to match the offer. Okay, what does this mean? Well, it means that when we look at an offer, we apply lots of different principles. For example, we look at an objective approach as to whether or not an offer existed. We could talk about whether or not a reasonable person or a quote reasonable man or a business of business acumen will have understood the facts of a particular case to have been an offer, and we say that this is an objective approach. Well, it means that this very same objective approach that we apply to the offer of a contract has to also exist when we talk about the acceptance of said offer. It should be noted as well that conduct may also be constitutive of an acceptance of an offer. So we will get to that in a second. But ultimately, the mirror rule tells us that we ought to really see the acceptance of an offer in the similar kind of way to how, or at least the process by which an offer is made. Let's look at a case as an example. This is a case from 1877, so a relatively old case of Brogden and Metropolitan Railway. The facts of this case are as follows. The defendants had supplied a railway company with coal without there ever being a formal contract in place. The railway company were the claimants, and the defendants were the suppliers. There was no contract in place to do so, but it was just a sort of general agreement that had existed between the parties for the claimants or for the defendants, should I say, to supply this railway company with coal. There had been a draft contract sent by the claimants, by the railway company, but no real formalities had taken place. So that a draft contract had been sent to the defendants, but ultimately nothing formal had taken place. No signatures, for example, had been made, and in addition to this, they just sort of carried on with their arrangement of supplying coal to the railway company. This was a process, by the way, that went on for up to 2 years. So draft contract was sent, nothing formal had taken place, and then as a process for up to 2 years, there was just this supply of the coal to the railway company. When the defendants then decided to cease the supply of the coal to the claimants would sue for breach of contract. But you might be thinking, well, they never actually signed a contract. There was no formal contract being in place. There was a draft contract that was sent out, and there was sort of the following of the terms of the contract in the supplying of the coal, but there was never any kind of formalities that had taken place, no formal signatures, for example. So the question here was whether or not there was a contract between the defendants and the railway company. And it was held that there was a contract because the acceptance of this contract was stipulated by the conduct of the defendant. So rather than actually signing the contract themselves, essentially what they had done was they had been given an offer to contract by the railway company in the actual draft contract itself, and then they had just simply performed the terms of that contract. And it was this performance and the conduct of the defendants that constituted the establishment of a contract that existed. The acceptance was stipulated by the conduct of the defendants, and the defendants were in breach of that contract by ceasing on a whim to supply the coal. It was found that where there is a draft contract, and that the parties have acted upon this draft contract by acting in accordance with its terms, they can become bound by said contract. So when I said in the previous slide that it should be noted that conduct may be constitutive of an acceptance of the offer, this is a good example of how this operates. Because what they're saying is there was no formal signing of a contract in the way that an acceptance could be established, but instead there was the performance of the terms of a contract that was a draft contract, and therefore this almost legitimizes the draft contract in question because of the fact that they had acted in a way which performed or was in accordance with the terms of the draft contract that was sent out.